make a motion, Your Lordship. There is a
Pass on the memo, madam, why you are.
Well, for a moment, may not know the last topic. Well, the entire road, they have blocked, and that there is absolute no reason, and that is post ritual. My Lord will kindly appreciate Ganesh Puja and Durga Puja. Both pujas, after completion and immersion of the idols, they stage dance, music, orchestra program on the main road. After constructing a stage over there, over the.
Have you filed your affidavit? Have you subsequently filed an affidavit?
My Lawrence Senior himself.
9-10?
What?
My Lawrence Senior himself is a petitioner.
Yes, what is wrong?
Yes, yes, ma'am.
Is it wrong? I think my learned friend is yet to know that Rule 6, even Dr. Kapil Sival Lawrence Senior would have in personal file PIL seeking Supreme Court's intervention on Schedule 10.
You are a veteran. You are a veteran.
I am conscious of that. Rule 6 of Bar Council of India, framed under Advocates Act 1961, says that a lawyer cannot conduct a case before the presiding judge if he is relative. And recently, Bombay.
Okay. When you are appearing in person, then you can appear in robes. That is what a BCCI rules, and because is an advocate who can represent a party, and the robes are prescribed. But once he appears in person, there is no bar. But at least the decency, ethical thing requires that he should not appear in robes. I was there for a.
But a lawyer is always a lawyer before my.
No, it's representing the client, not representing. Can you represent yourself as a lawyer?
Yes.
Then, so that is what he is raising an objection. Anyhow, these are all, I leave it to your wisdom. I do not go with that technicalities.
I had the impression, sorry. I had the impression.
So I leave it to your wisdom to consider. Anyhow, yes.
So now in this case, I'll my Lord, kind of look at page 20. Page 20. Kind of look at the blockade. In that case, I have to be careful because my Lord observed that I should not appear in roads. I'm sorry for that. And this is the public road. This is look at this. Blocked. And for 10-12 days, they continue to perform that dance, music, orchestra, etc., preventing the members of the public to commute, to reach the hour next to the structure, and kind of have a look at page 22. That also I had a page 22, my lords. There is
Also executed a Vinama.
Pardon
You have executed a Vina.
Yes.
Who has executed?
I have
Vinama is executed by whom? Like him.
Mr. Pradhan has to file this. In any case, consider that technicality, I want your lordship, as my lord would.
We understand the other aspects of your concern, but this is equally a thing which, if it gives, will allow it, will not give a good gesture.
You can revoke, there is no difficulty. So it can be revoked of Wakalatnama at any point of time. No problem. There's no bar.
No matter if I am appearing in my robes is a difficult.
No. That we are not saying any difficulty. We are just reminding you
Oh,
of.
yes, I'm careful. I'm sorry when I start this, at this stage and age, I have to be, I'm still learn. I still learn. But I had,
Everybody learns.
I had the impression that as per Rule 6 of our council,
Please look at that rules. It says that your
one can
relative
appear.
is a relative, but
Okay.
there is no bar in appearing in person. There is no bar. But the Wakalatnama is executed, and at least I believe Wakalatnama has to be cancelled. They go.
Still, power file may be withdrawn of Mr. Pradhan.
It is up to you, sir. How can we say anything about it? We are
for this
reminding you that
Well, for
this is
session,
what
I'm-
appears from the record, actually. We are just reminding you,
Yes.
nothing more than that.
But I am
We are not
permitted-
saying anything what to do, what not to do.
But I have been permitted to pass some affidavit just to apprise your lordship. Just to apprise your lordship, can I have a look for a moment? The designated place for performance of puja, installation of Lord Ganesh and Lord Durga is already there. Can I have a look at page 4? Just kind of have a look at page 4. This is a and there is plenty of space in front of it, another main road leading to the other locality. But
Please also be.
putting barricades to assist them to prevent the road public. where the idols are installed and happily they go on performing the rituals. And after the immersion, before 2-3 days before the immersion, and for 10 days beyond, kindly have a look, my lords, how they have kind of.
This is what affidavit you have filed.
My lord?
This is the affidavit you have filed, additional affidavit.
Yes. Additional. I have given the copy.
No, it is there. Two photographs you have annexed.
Yeah. And here also kindly have a look for a moment.
And what is this?
And this is another affidavit where I have shown my lords for kind appreciation. How
Sir, these things are going very contradictory at times. It is going very contradictory. A senior advocate is appearing, being identified by another.
my appearance, I'm sorry, I'm answering. My appearance in my robes
Can you give
is
the
the problem.
advocate's act?
I pardon. A senior advocate appearing in the robe is the problem. Otherwise, in person, I have filed the affidavit. In person, I am bound to file the affidavit.
No.
I'm extremely sorry and pardon for those technicalities, my lords. But kindly have a look at the merit of the case. When there is a designated place for performance of the rituals, and vast area is there across the road, and the road is leading, a main road is leading to other part. They block the entire border village road for 10-12 days. I'm extremely sorry, my lord, for the road. With permission, my lords, I may share my road. I pray my lords to kindly have a look at this photo. Kindly have a look. Kind of look for me, that photograph. The police is putting barricades and preventing the people.
The barricade is at the side of the road. There is structure as if created from this photograph it appears. Yes. It has been kept by the.
No, but there it
So the
is.
road is absolutely smooth. They have to keep
No.
as the barricade.
During daytime they have kept it aside. During daytime they have kept it aside.
So that I don't know, but that is also not really reflected from this affidavit. You are saying something which is not needed here. Now let us go through the.
Yes, my lord, that is exactly what my kind have to look at page 23, my lords. Kindly have a look at page 23 of the main read petition. Well, my entire submission is the road is being blocked, and from the evening 5 o'clock to the whole night functions are going on the public road, and the people are prevented not only by the organizers but by the police putting the full barricade in front of the, even on the bridge, the main entrance, the canal bridge, and a group of police people stand there and do not permit the people to go, residents to go to the village. My lords, every citizen, my lords, my lord, Chief Justice, my lord, Justice Ramon, observed the other day that every citizen has a freedom right on Article 19(1), have right of way. Read with Article 21 also.
No doubt about it.
And recently, my lords,
Yes.
Patna High Court has held that even for freedom of religion cannot override the public order.
No, public order is one. Public inconvenience is another.
Kind of thing.
Law and order situation is always you, that is in the stateless entry war, which is a state subject, no doubt about it. Law and order, but the question is, the law and order one, public inconvenience is another. Now, public inconvenience has to be just in that person. If two individual rights, fundamental rights are clashing with each other, then what should be the parameters which the court should be in balancing the fundamental rights of both the
Yes,
individuals?
ma'am.
So that is what is to be
My-
considered. If it is in a larger public interest, then I think the category of judgments are says that individuals' right that could not stand in the way.
But it's not
Other
part-
public
But how kinds of voices
That-
kindly appreciate for a moment, my lords.
those last
admittedly road is blocked, despite alternatives, and have a look. Where alternative is available much more, about 1 acre land, that kindly have a look for a moment at page 22 of the requisition that I had drawn your lordship's attention on the last week. This is they have kept it reserved.
Yes.
And for
It appears that except him, there nobody is coming.
yes, yes. I'm sorry for a moment. I'm sorry for a moment, madam, to interrupt. Thousands of voiceless people are representing. It's not they can't come directly to your lordship. That's the only. I have personal no interest. I have no personal interest on thousands of people. There's serious inconvenience, my lord.
Lordship,
They are
for a
blocked.
moment, kindly
Where is
read
your
paragraph
house?
7.
They have blocked the road.
Where is
blocked.
your house?
My lord,
Where is your house?
my house.
Only 50 meters
Next.
distance, at the distance of 50 meters from the puja pandal.
Next to the just road blockade, next to the structure, just next. That for me, matters it's not. I have to stay outside for the whole night. That and or I have to remain confined in my office room or office. And during office time, office hour,
No, you said that is what.
But see, basic
There
page
is no
2 class
personal
line.
interest in the matter. That is why I asked you.
Right.
You say that you have no personal interest.
I have mentioned that also as per the format I have
Page-
filed the.
Lordship, may see
As per the format I have filed the.
page 2,
public
page
litigation.
2 last line. Page 2 last 2 lines.
I have clearly stated that thousands of people of that locality who are unable to directly approach my lords have approached me to present their grievances before my lords. And how can I have any personal interest there?
Page 2.
Page 2, Millard, last 2 lines. Paragraph 5, last 2 lines.
But the representation which has been submitted to the collector also
Yes.
reveals that only your signature
Yes.
appears.
I have,
Doesn't bear the signature of any of the inhabitants.
I have personally drawn the attention of the inspector, local inspector and also commissioner.
But the representation should be there before the PIL by the people.
Yes, my husband kindly appreciate representation of my representation on behalf of the entire people that they are facing. My lord, for a moment, I'm sorry. Even if I am personally a conscious man, member of the public, draw their attention that public are suffering. I have not come to
Why did the public are suffering? Not a single person has come forward. This is the public interest litigation. If anybody has any issues, he could have come and seek his implement as a party. He did not come.
that
But
way.
you are espousing the cause of the larger section of the society. From their affidavit it appears that none of them have ever raised it. Rather, they were more happy in having those ceremonies organized there because they are wholeheartedly participating in those at the very temporary days, like a Durga Puja or a Ganesh Puja. That is the only two issues that.
Puja is being performed in designated places. That photograph is shown.
So this is.
They are blocking the road for the purpose of
Are coming.
music performance, dance performance, all this in the open. The honest, that is the only thing.
If it is
And
indecent.
my only.
Sir, only thing is, if those dance performances indecent, it is not in a more, sophisticated or in a more, I would say, the reasonable manner. Then in that event, you can say that these kind of things are not really want, but
I will be.
nothing of that kind has come out.
My studied
If it is a religious dance, which is a dance form
perform
sometimes
religious.
since the archaic age.
I have shown photograph. Religious function is being performed in its.
We don't know, now the singing,
Blocking of the road. Eat milers.
it is not that it has come up. And it is a very temporary one, for a period of 10 days.
10 days.
They are,
Twice in the year.
Sure.
Twice in the year.
they are sure that there is already an alternative routes are also.
Yes, sir.
not for that.
Alternate route not there. For this
But they
village,
have affirmed that it is there.
my rounds and rounds to one way. That is Well, every place has an alternative right, but grounds and manus in any case, my humble submit.
You are granting a permission.
Yes.
So why don't you think that what are the
police
requirements under the
should
law? Now, what are the requirements under the law? If somebody organizes the community, say the religious functions, so they must seek the permission. The permission is within the domain of the police administration or some.
Police or municipal corporation.
This what they grant. So if they grant a permission, then
Can it be conceived that a road will be entirely blocked to
No, it is not confined to.
police will assist them
It's also
me or any.
all over across the state, you will have to show. And
Police have to
once
Police
that is there is one auto passage. When one car can move, you have to leave it open.
On this entrance from 5 o'clock to
Only
4
one car, at least the moment.
They
High
have
Court of
stated
Orissa.
that it is from 7 p.m. to 10 p.m. They are performing cultural programs. And Millard, for the free passage of the locals, Millard, that is arrangement. That's why the barricades are put in the middle
If
of
the
the.
public road is there, how can it be blocked for any purpose?
No, it cannot be.
It cannot be blocked. So that is what Lordship is saying, that it should be arranged in such a manner.
Just draw your lordship's attention to para 13 of the pleadings in the writ petition. Two paragraphs, my lord, 13 and 15. That will show page, page 10.
Paragraph 14.
1, 3, my lord.
One
P. 1
I'm sorry. Lordship should read the last 3 lines.
You're seeking that it should be done in the open tender. That is,
I'm not.
tender has not come.
No, I'm not. That is the petitioner. I'm for the OP 3 and 4. We had raised that objection regarding that this should be treated as a tender matter because the ultimate, what he aims at, that it should go for open tender and this rate contract system should be abolished.
That is a different, that does not render it as a tender matter.
I understand, my lord, to that extent, and not the other objection, my lord, that is on
It should
merits.
go a single bench. Why it has come up?
One border
Because
and
of the
this
stamp
issue.
reporting, because of the stamp reporting, in the list it has been mentioned. A further SR dated 21/5/2026 has been made,
We have
wherein it
final
has been
application.
reported that the subject matter of the present writ petition relates to
Where is the
tender.
annexure 6?
Yes. That is 63 minutes page.
63. Earlier order he has passed kept in abeyance order, my lord. Here, he asked for a report from the
That
BIS.
is the direction of the director.
Yes,
yes,
yes.
Nothing to do. That's
Yes,
what-
that is the challenge. Not a
The matter is listed today before this page. As the staff
Item number 3.
Kindly pass to.
Item number 4.
Delay of 289.
Service. Who is appearing?
Item 2.
Once.
One service is affected or not?
One is. Yes,
My lord, state has filed a batch of deed applications, my lord. Half of the batch has been dismissed by your lordship. Kindly have a glance for this, sir. Further, it was challenged in the SLP. SLP imposed 10,000 cost on the state, my lord.
Yes.
What are you talking about?
My lord, I am serving the copy of the SLP, my lord. Then after state has thereafter state has filed a review, my lord. It has also been dismissed.
I'm told that in the meantime, they have also complied the direction of the Honorable Court and they have released the
Compensation,
compensation has been released. That amount of 85,000,
95,000.
95,000 they have already received. That is what my friend was.
Management may-
Original SPCA was 95,000, 10,000 was paid, 85,000 100.
After 2 years,
Ah.
they reviewed everything and said that
So it is already complemented.
implemented. That is what he said me, but I have no specific instructions. But so far as
Whatever, we have orders of the Supreme Court. One says that SLP is dismissed without interference. Second order says that review also dismiss.
and in the contempt proceeding also, they have brought the state authorities. They have
This
already
was
brought this
arising
notice
from
of
a
the
common judgment.
yes, common judgment, but this case has been decided individually, but relying on the judgment one. Yes.
So what remains here? Even if we condone the delay, but on merit, the Supreme Court has very meticulously gone into this aspect.
Yeah.
I think this is after the notice.
My lord, no, my lord.
This appeal arises from which order?
It is that order is that annexure 4, madam.
Give me a date.
For the order dated 3/3/2023.
3/3/25.
Where is that? So that that is a review. That was a review. What about the main judgment? I was just.
As far my instruction is concerned, most of the people have already received the comment.
No, that is already.
No, we are talking about you are relying on this Vidyut sound judgment.
My lord.
But I do not find the order by which the SLP is dismissed. You are giving us an order by which the reviewer was dismissed. And this order, which affirms the order of the High Court, was a Kasturi Nayak.
No, I have given my lord, sir.
Oh, minors, you have given a different copy. Okay.
Oh, both. Given this. Kasturi you have given?
Kasturi is here.
Kasturi.
No, this is, I am having.
Oh, then.
Kasturi, I am talking about Vidyut Lata.
Vidyut Lata's original, not review.
Original are given my lord.
Where?
This is
I have the Kasturi Naik order, my lord.
So I also have a Kasturi. No, these are the High Court's order. What about Supreme Court order?
in
My lord, two orders I have given, my lord.
No.
Another one is Chandabhoi.
Are you not understanding what we are saying? You are relying on a Vidyut Lata's order.
My lord.
You are handing over this copy of the order where the Supreme Court has really on merit dismissed.
My lord.
That was a Kasturi Nayak.
My lord, the batch of application has been listed on the Supreme Court, my lord.
I do not find the reflection from this order of Kasturi Nayak.
This is the
Vidyut Lata SLP is not with us. It is a review. No.
He is giving, that is what we are having.
The review petition.
Look at the cost title. Cost title, look at.
But all the matters have been listed batchly. That's why they have communicated us this only 3 certified copy of this order. The Supreme Court has communicated us.
I absolutely understand. When you are relying on a Vidyut Lata's review order, that means there was a dismissal. There was a dismissal.
Original SLP must have been dismissed. Thereafter, the review has been filed.
My
So,
lord.
what is the original SLP?
These are the original I have given, my lord.
Original is only with.
Lord, maybe let me assist my lord.
No.
Two other SLP listed along with this diary number converted to SLP number 27183 of 25, 27186 of 25. Let me just check whether Vidyut Lata is there or not.
No, even if Vidyut Lata is not there, we can rely on
Yes.
Kasturi. Kasturi is also the same thing.
Same, my lord.
So we can rely on Kasturi, not Vidyut Lata.
These certainly relates to funny compensation.
Absolutely. This case is also funny.
Is yes.
So what is-
you are taking a statement that he has already got it.
Right.
So therefore you are also taking this food out. If he has already got the relief, why don't you make that?
I've got it.
Out of there are 60 cases filed. Half of we have got.
You are concerned about this case now.
Half of the petitioners.
Talk about this case, sir.
Talking about this writ appeal,
Yes, Malti boy,
we have not got.
you have not got.
No.
That's all. You have to come very specific, sir.
Just check. PPT.
How much was awarded here? 85,000?
My lords.
The 95, 10 has been.
10 have been already released. At the initial.
We are not going into that aspect. We are simply, how many days delay? 295?
Wait.
289. Right?
Blood, the first one is Vidut Prata. Yeah. The first one, 27183. Blood, your lordship is holding Kasturi.
Yes.
Yes.
So the first one, 27183 of 21 diary number. That's
Yeah.
the got it. It has come along with two other SLP. Diary number 43884 of 2025 corresponds to
I
SLP
know.
number. Yes.
I
That
know.
is Vidut, sir.
Okay.
Yeah.
So,
So
it
that
has
is,
been
that is not there.
Batch it has been disposed of. No, no, it will not come separately. It is
Anyhow,
external.
so we are condoning the delay
My lords.
and we are disposing of the order.
It's
That's all. On the basis of this.
Yes.
This is an application seeking condonation of delay in filing the instant
Certified copy will sir.
Yes, you take it back. We don't want. Only thing is, if you can give a photocopy, they will quote paragraph 7
Madam.
for that reason.
Item number 2.
Item 2, there is a delay of 109 days. Okay.
Notice has to go or issued
My lord, I am appearing for opposite party.
without any notice.
My lord, because in contempt they have given the number, so I am appearing.
Okay.
Because my lord, this is order.
Sir, the copy, have you received the copy of the condonation?
No, my lord, I have not received it.
Sir, in course of.
Record his name. No notice.
There is a delay.
Anybody appearing?
Somebody has entered.
You have instruction? Serve with the copy or not serve with the copy? Same order.
Madam.
Item number 4.
Similarly, 7 days.
First you serve with the copy.
Item number 4.
Well, 4 is an appeal against an order of impleadment.
Against an order of?
Impleadment. Well,
The impleadment application is allowed.
the impleadment application was allowed. Well, an association was added as a party.
Huh? Today is listed for a delay, sir. There is a delay.
Yes, well, there is a delay, my lord. We'll have to pay for
So
confirmation.
notice has to go. Notice. Returnable, how soon requisites can be given?
Well, we can give it, I suppose, well, in a day or two.
Within 2 days and service after 2 weeks, let it apply.
Item number 5.
Item number 5, I find an objection. There is a delay of 7 months, more than 7 months. And delay has not been explained.
Are you seriously
So
contesting?
I am seriously contesting because
Seriously?
the respondent is going to retire 2 months after, in the month of October. Now they have, because of the contempt application, they have deliberately made this appeal to somehow avoid the contempt proceeding. If your worship look to that, your worship delivered a judgment, so far the limitation is concerned, relying upon the judgment of the Supreme Court, I think my case is squarely covered by that. I have brought that judgment and how they have explained the delay also looking at.
Where is the application?
The application of this paragraph 5.6.
Yes, number 1, 2, 3.
So there is a caveat. You have been served with a copy.
Yes, yes. Copy, I also find an objection.
Copy of the counter.
No, I have already received the copy and I find my objection.
Yes, received the copy and also served the, filed the objection. And you say that you have not served the objection.
In fact, if you also look at paragraph 5 and 6,
No, just give me 2 minutes time. Order is dated 13th.
To the paragraph 5 and 6. In fact, admittedly, the judgment was pronounced on 1310. According to them, they received the copy of the judgment on 1610. But from 1610 to 1710, 11, they say after 1 month, they moved the government to Home Department. There is no expansion. That is from 1610 to 1711. Then from 1711 to 30/12/2025, no expansion. So it was a detailed note was submitted to government to the Home Department. Then if you also look, then no expansion for the period from 30/12/2025 to 27/2/2026. And they said that government Home Department endorsed the file to Law Department. And the Law Department, if you also look, from 27/2/2026 to 2/5/2026, 3 months, no expansion. No expansion. Then I cannot say anything about the Advocate General Office. There is normally little bit delays, but these delays, at least more than 7 months, your Lordship judgment, you also kindly look to the judgment your Lordship delivered. Of course, in 2026, relying upon the judgment of the Supreme Court, that also I have given to your Lordship one paragraph. So far the state is concerned, that your Lordship referred to that very language your Lordship have also used. Yeah. Your Lordship judgment is paragraph 6. Paragraph 6. And this judgment was delivered in February 2026. There is no quarrel to the proposition of law that the court should not be swayed by the length of delay, but must be guided by the merit of the explanation offered in the application for condonation of delay. The length of longer period may be condoned provided the court finds the ground assigned in coming within the purview of the sufficient cause. May reject the application for condonation of delay of short period in the event the explanation is scanty and or not plausible. The narration of fact as stated above does not instill confidence upon us that there has been a sufficient explanation offered therein. A copy of the order was duly communicated to the department way back on 29 July 2022. Yet the pleading is silent for merely 1 year when the decision is said to have been taken for filing an instant appeal. We can well appreciate the step having been taken after the approach is made to the Advocate General of this court. The time consumed for preparation of memorandum appeal, along with the other applications, including the one before us. But we cannot overlook the fact there is no explanation offered between the periods defined from the date of communication of the interim order and the decision having taken for filing of the instant appeal. The state of the instrumentality can be regarded as the privilege in litigant. The moment the court finds that there has been a lackadaisical and dormant and lethargic attitudes perceived from the conduct of the official who are supposed to take prompt decision and having not taken so, cannot accept the blessing of the court by condoning delay. The moment the court does not find the explanation to be satisfactory, there is no failure on the part of the court in refusing to condone such inordinate delay. We thus do not find any merit in the application for condonation. And the judgment of the Supreme Court also kindly look. Paragraph 27. Only so far the state is concerned, so far delay is concerned. Paragraph 27. Delayed appeal to defeat the implementation. Page 19. Paragraph 27. Delayed filing of appeal. Sorry. Did you get it? Yes. Delayed filing of appeal should be the exception. But in recent times, the exception has practically evolved to become the rules. Orders passed by the court are not complied with for a long time. And when contempt petitions are filed, belated appeals with a tremendous delay are preferred. the continuing contemptuous conduct of the defaulting party is sought to be justified on the mere production of a diary, filing or stamp reporting number showing that an appeal has been prepared, so as to obtain multiple adjournment in contempt matters. We, in no uncertain terms, defend this practice. It is clear that by such modus operandi, disobedient litigants act gradually, which has the further effect of bringing down the authority and majesty of the court and the rule of law, interfering in the administration of justice. The same may well in certain situations broader on criminal context. Then 30. The High Court should deal with such unscrupulous litigants more so when they happen to state within the meaning of Article 12 of the Constitution or like bodies with an iron hand. Unless the High Court so also the court deal with this aspect firmly, we run the clear risk of erosion of the unfleeting faith that the ordinary litigants of this country repose in the judiciary at all levels. It is the solemn duty of all of us manning the court across the hierarchy to ensure that the public faith never wavers. So this is a case which is going to retire 2 months after. And contempt petition was filed. In contempt petition, orders were passed time and again. And subsequently, not to avoid the contempt, Lordship knows that judgment also. So far the contempt, once the contempt application was filed, to avoid the contempt, you can't file and people the appeal. That is what the case is. Otherwise, I would not have pressed so much to objective delay. He's retired.
What is the nature of the litigation?
The nature of the litigation is the vigilance case was initiated.
30,000
Just
application.
30,000 or 30 lakhs is not a matter. Basis of disciplinary proceeding of the vigilance case. Now the vigilance case, clean acquittal, honorable acquittal.
No. You are using that word honorable acquittal. That's why I'm asking, what was the ground of acquittal?
Acquittal.
That the witness turned hostile or...
No, that's
Suppose if there be a situation like that, at a show cause notice stage, can the court quash the entire work? Because that you may take a defense that you look in a criminal proceeding.
I understand what your is asking.
That is
what
what...
At the stage of show cause, here is a case with the basis of the disciplinary proceeding.
No, I understand. I'm conscious of the Paul Anthony's judgment of the Supreme Court right from there.
Yes.
And ultimately, I think the GM tank is also one of them.
Yes.
And subsequent thereto, there is a judgment.
Yes.
GM tank for the first time brought out the concept of an honorable acquittal. In Paul Anthony, it was not a case of an honorable acquittal. Paul Anthony simply proceeds that if there is a similar witnesses, same nature of the evidence, same allegations, everything same.
Yes.
Then the acquittal in the criminal case will impact the disciplinary proceeding.
Right.
But we must know the distinction between the criminal cases the mode of disposal of the criminal cases and the disciplinary proceeding.
But if
One is beyond any reasonable doubt and one on a preponderance of probability.
Right.
So both stands on a different footing.
here is a case of beyond reasonable doubt.
All is the
All
That is why, that is GM Tang came, that every acquittal does not come. In
Yes,
fact,
sir, yes, that.
it should be an honorable acquittal. What is the honorable acquittal?
But that question here, why I am saying so, subject to lordship's acceptance. Here, the disciplinary proceeding was initiated only on the basis that a proceeding has been.
No, there was a serious allegation, sir.
So allegation is
The bribery,
that has been already.
red-handed, and the bribery was there, and for that the FIR was also lodged, and this is the case setting.
The lordship knows that acquittal, and they have not challenged it, and they have not also gone in appeal, leave to appeal, or they have not, state has not gone in.
What was the reason for acquittal? I just wanted to know.
So reason it was judgment for which? Then you also.
So that we can use this.
No,
Let us give a.
So you are the appellant. I am not the appellant. And you have given this copy.
Who was this?
Oh, he's correct, Mr. Rautre. It's your copy. Your junior ought to be very careful.
That's
So,
I'm sorry, I thought that state as a respondent. Yeah, but the charges are very great. Please,
Because of my retirement after 2 months, I don't say that, sir. This is the only, they have not challenged the judgment of the criminal court and they have accepted it. Now the basis is only because of vigilance case. And in fact, you are right, from the very inception, it has been granted interim order was passed by the tribunal and ultimately the Honorable Court was that. That is the entire case. Same witnesses, same nothing. The list of witnesses which are supplied to the petitioner, the same, exactly same.
in the criminal vigilance case, they could not prove the demand of the gratification. It was not that he was caught red-handed with the gratification.
That's it.
Was it not that case?
It is not a case of trap.
No,
Space 28.
I find from the finding of the single bench, it says recorded that criminal case.
Criminal cases, though. They could not prove the demand, not that.
No, the FIR was also lodged that he has
Yes, yes.
demanded as illegal gratification.
No, it's not a case of trap.
Oh, not only the demand.
Case of trap.
No, it's a case of trap. It cannot be otherwise. There is a question of demand.
No, no.
Case 28, you are not
Just-
justified.
I- I-
Very good officer. Must be
What, sir?
Allegation.
The gentleman who, according to you, used to pay turned hostile.
that is separate, but this is suspect.
That is what is the difficulty.
This kind of people in a police station. Asking. And the moment he joined, he started collecting. Next one.
Negotiating witness is paid. That's because every of the other witnesses over the action comes it's going to be court that I am so trying to really be into the subject of not even if this already witness getting about it, they will not believe.
There is a complete gap. We are conscious that day-to-day explanation is not required, but at least there should be some kind of a continuity in your explanation. There is a complete gap of 2 months, 3 months in between two.
At paragraph 4.
Yes, please read that.
That delay on 18/11/2020.
No, sir, you just start. He has correctly assessed. 3/10/2025 is the date of the order or a judgment.
Yes.
Then you received that particular order on 16/10, well within 3 days. No difficulty. Then state police headquarters received on 17/10 within 4 days. No difficulty. Then the entire thing was processed. Then 17/11, the government of the Home Department is seeking a view, another file. So now the period gone, limitation over. There is nothing that what happened between 17/10 to 17/11. Then if you have recreated a file on 18/11, then why detailed note on 30/12? This is more than 1 month is required. What happened in between? What has happened? First thing is why you created a new file. There should be an explanation that was the reason we have to create a new file.
This is not a new file.
What is this?
This is OSWA's file. Generally, what happens?
It comes in OSWA's.
Continue.
Yes,
Whatever, OSWA's, whatever, then you'll have to say that why you created so late. What was the reason?
It is 17/11/2020.
Already the limitation period gone.
Yes.
You received on 17/10. Why? Between 17/10 to 17/11, what is the gap? This gap? What is the explanation?
This is to be read between the lines. Because
Sir, this is section 5. It is not a so easy normal writ petition. Some kind of a nexus has to be created. Even 1 or 2 days delay, unexplained days, we can understand. There is no difficulty imposing the cost will compensate if the overall things are there. But you'll have to just fill up those gaps. And then 18/11 it is created. Then why 30th December? In between what happened?
30th December detailed note was submitted.
True. For what?
Is the matter to the government Home Department.
Why? What happened? In between 17/11 or 18/11 and 30th of December?
It was pending. It was pending for consideration.
I am asking you that what was happening and you have to say something.
then we will have to explain all these things we try in academy.
Yeah, this one.
I don't know. Because we are just focusing those what we try academy.
Then from 30th December to 27th February, nothing.
And then we wrote 27 2 to 25 in the law department. No explanation whatsoever. 27 2 to
Because the
25.
Home Department approached the Law Department, and the Law Department, what the Law Department was doing from 27 to 25.
30th December 25 to 2026. We file academic to explain all. Because we are all
I'll ask the law secretary to file an affidavit. I'll ask him.
Because they have to say that what they have done.
Why will not the file?
Done some kind of
5 months. I'll ask him.
when the learned advocate general is there, he knows that something in between.
Lord, I let you not make further statement here. I know what goes on. Your lordship also knows what goes on in the government. Even after 5 years, they are coming with a problem. So every day I can't make a call with the officer. That
Yes.
Consulate, but I'll ask the law department for what were they doing. In many of the cases, I'm experiencing this difficulty in Supreme Court also. Law department 7 months, 8 months, 10 months. I'm explaining that in Supreme Court also. I'll ask. In one case at least.
I'm putting that question to myself. Is it permission?
My one friend was also an additional government advocate 20 years back. I think he must have filed many such things. So he knows what happens in the government.
Additional
Let
affidavit.
me not speak for that.
Man. Item number 6.
Item 7 is also similar to this 5. Good. 5.
Same.
Similar to 5.
Same what? 11. Is 6 what?
Manoj, there's a delay of 41 days.
Notice has been issued?
No, man.
Notice 2 weeks.
Manoj, may I get out? Manoj, the issue is covered under another order. Manoj, the stated order, one writ appeal has also been preferred against the stated order. Manoj, both the matters may come together, Manoj.
We'll see to it once.
Item number 8.
Let it come back.
Obliged.
8.
Delay of service.
Yes, date is only stated the
So what? Will you not serve?
we've stopped copying.
Where is the service?
Lordship.
File the objections.
How many days delay?
160.
So it is a case of honorable acquittal as well.
And the delay of 4 years, my lord, just first delay of 4 years.
Delay of?
4 years.
No, 57 days.
No, 20.
Item 9.
Item 9.
For age 22.
Item 9.
1371 days delay, sir. What are you doing?
So it would. And it is clear that.
Is a stereotype application, which we dismissed earlier? Relying on one judgment, which has been explained and distinguished in a subsequent judgment?
Yeah, that's on
Where is a
Earlier was
condonation
more-
application?
Descriptive than this.
Where is a condonation application? Like E.
Earlier was that at least having some paragraph. It doesn't appear.
Oh, same judgment. No, this time he has not relied. My goodness. This is a high time we should impose a hefty cost on the paragraph 3 and 4. The first line, tell me, the writ petition was disposed of on 24/8/2022. And after the examination of the order, as per the instruction, the decision was taken on 23/4/2026. Interesting. You took 4 years to take a decision whether to go or not to go. No. High time. Have you been served? You are opposing without service. Are you opposing without service? Oh, he is opposing. So we are dismissing. No, he does not want. What kind of a petition is? No. The instant writ appeal has been filed.
57 days delayed notice.
Yes, notice 2 weeks.
Item 11.
193 days.
193 days, 3-day mallet, abundant caution mallet to meet this application. Abundant caution mallet, under the technicalities, we have to meet this application.
Abundant caution means there is no delay.
I'll point out, mallet, if you lordship, kindly allow me 1 minute, mallet. Mallet, the original order, mallet, the original order, there was an appeal pending. Pending that, mallet,
Here's the original order, the appeal is pending.
yes. And without our, mallet, even, mallet, we'll come to that later, a review petition filed, ex parte order passed. During the hearing of that original order appeal, mallet, we come to know of this order. And then we filed it. Mallet, so we
No, review order has been reviewed or review rejected.
reviewed.
Then the original order merged with the review order.
Yes, mallet. So therefore I had to
So there
file.
is a delay.
Mallet, that's why I said, mallet.
Not from the date of the knowledge, but from the date of the order under the Limitation Act.
Yes, mallet, I pointed it out. I was never served.
Under precaution,
No, mallet.
you have to file an application.
We have.
Mallet, we have filed. That is why we have filed.
Service. You have to give a service. So it's returnable after 2 weeks.
Only that other writ appeal may be tagged.
Mallet, that is one thing, mallet. If you lordship can kindly tag
That is merged. It is
No,
not
but
that you just give a number, we will,
Yes.
we will tomorrow at 2 p.m. mentioned, dismiss it.
No, mallet, may I, mallet, with humility, mallet, may I just make one submission, mallet? Mallet, I have also challenged the here, mallet, has been passed without notice to me. So, mallet, that part and whether that order could have been reviewed is also before the lordship, mallet.
Order, we can quickly err on.
That's why, mallet, I said there was a stay of that original order.
You can give the number.
Yes, mallet, kindly just not dismiss it, mallet. No, dismiss it, that's it.
It may be dismissed on the ground of limitation.
Yes, mallet, that's why I'm keeping that, mallet.
Don't.
No, mallet, definitely not, mallet. That is why I don't want anything to be dismissed, mallet. Let them be there with the lordship.
Item 12.
Yeah, grateful, mallet. Very good.
May I please not find an order for the completion of below 40 days?
You will serve the copies.
No, no.
Item number 13.
13 minutes, respondent number 3, my lord. So, Patra is already appearing. I'll serve a copy on.
I'll already appeared for a private respondent. That notice is already entered.
Not I received
the copy. Coming the copy.
There is no delay. There is no delay. It's for admission.
Yes, press admission.
So just give us 1 minute. The first, the back, and for the left. There is one judgment which I have delivered there. Taking giving an undertaking does not really take away the rights. Maybe terrorism, maybe under a caution. With reference to Jagdish, because he is an employee always under the threat of being evicted or thrown out of the job. So, only thing is that whether on the legal point, whether it is permissible, you have quoted that 29A of the star rule, and it says that if both the spouses are working, then they are entitled to only one house rent allowance. Where is that? And why the tribunal has discarded your country?
Tribunal has, I have to put the facts before your lordship.
Fact is very simple. Both husband and wife are working with you. Now they have drawn, both of them have drawn the HRA.
Not both were working. One of
You
them was.
say that the both the spouses were working is there in the cooperative bank.
In fact, your lordship has the.
That is the promise, I think both of them are working.
First, it got 29, it got amended subsequently. So what has happened is, in fact, that's why I need to put the facts before your lordship. 2003, the new rules came in. The new rules were kept in abeyance. As the bank did not want to get into the financial aspect of the thing, and since it was a huge financial burden on the bank. Subsequently, the RCS, the Registrar Cooperative Society, he amended the rule. When the new revised scale of pay came in 2010, the amounts were dispersed and wrongfully, the amount for both the spouses were dispersed. And the person who is employed with the bank and the person who is working with the state government. So what happens in the stand of the bank is that since one of the employees is already availing benefit under the HRA allowance.
That is what we are saying.
Yes.
That is what we, at least I have not said differently. I have said, Mr. Nanda, the same word. The question is Rule 29A, how it is to be interpreted. If both the spouses are working, whether they are entitled to only one HRA.
Yes.
And why the tribunal quashed?
The lordship has page 49 for a moment that the tribunal has extracted the relevant rules side by side.
Yes.
Page 49 the lordship has.
True.
This was rule 25 of 1990 rules, which is the first law, when it was stated that the shall be paid 25% of the basic pay subject to minimum of so and so, maximum of so and so, and unless otherwise revised by the committee. Now, initially they were getting on this, no issues. Subsequently, in 2003, the new rules came in 2029A, which say that HRA at the rate of 15%, the basic pay provided only one of the working spouses shall be entitled to house rent, even if they work in different offices and establishments. Now, thereafter came in the revised scale of pay, which is order number so and so of the government, RCS, which says that the house rent allowance shall be 15% of the basic pay with effect from so and so, and 20% with effect of basic pay with effect from so and so. So at this juncture, what happens, my lord, is the bank, if you lordship comes straight away to page.
No, I do not want to understand. At what stage you wanted to develop?
This is after coming into effect of the revised scale of pay, the amount which had.
What is their total year of service?
The lordship comes to page 88.
From where you want to recover?
That's what I'm saying, my lords. The revised scale of pay, which in lordship comes to page 88.
Be asking that
Page 88, the revised scale of pay came in. If your lordship comes to page 90 of that, page 90 of the thing. No. As I said before, lordship, the house rent had not been paid. They are kept in abeyance, awaiting the revision of pay scale and the amendment by the RCS. Now, your lordship sees the house rent allowance shall be paid at 50% of the basic pay with effect from 1/4/2026 and 20% of the basic pay with effect from 1/12/2008 onwards. The clause 28 of the bank stand modified the extent provided that so and so will be applicable to the employer after coming into effect. Now, what happened is
has come only after the retirement.
no, they have not.
They're still continuing.
No, they have already retired.
Now they're retired.
No, at what stage they wanted to recover it from where?
From 2012, my lord.
It's
What's the
This demand was raised when?
it was raised in 2013.
13?
2013, when you got, when you were superintendent, you are superintendent.
After that.
After that. After that.
Yes, what happened, my lord?
So much happened.
That instruction I have.
And what is his role?
He has not no
What is his position? The what category?
Class 3 now. Class 3. Group C. Class 3. I don't have logical.
I'm asking. No, 4. 4. That's a group D. Traffic machine.
That's why the
Traffic machine.
Basically,
No recovery.
in short, my lord, I'm fighting a bout between Jagdev Singh and Traffic Machine. My lord, I'm relying upon Jagdev Singh. My lord, if your lordship may permit,
Justice Chanchu Jana's lecture on.
yes, Jagdev Singh says, yes, with regard to the undertaking.
But it's a different.
My lord,
I had an occasion to deal with both.
my case before your lordship is.
Find out my judgment over there,
My lord,
where I have distinguished both Jagdev Singh and Rafiq.
yes, I'll verify that. My lord,
I have said no on the case undertaking.
the other point I'm canvassing before your lordship is.
Jagdev Singh is a different. No, you have the copy of the Jagdev Singh. But this is Chanchu.
Yes, compilation.
That ground also half time facility to read.
Like, show me the judge. Yes, well.
So, Jagdev Singh, relied upon serial B. Serial B of that list of citations, substance over form. No, which one? Bulbul. Serial number B of the list of citations. Legal effect of a document depends upon its content, not its title or name.
Yeah.
So if the lordship has a look at that document, which is the undertaking, at page 141. Lordship has a look.
No, it's not required.
I will be putting a question.
Don't worry.
My doubt on that.
First you open your card, then I will open my card.
Yes, my lord.
Yes. So you have relied on Jagdev Singh. Now thereafter you are relying on this
Undertaking
substance over the form. category. What it says, I guess those can be my submission to the election. Yes, the university may come to page 141. Very deeply. No, not 40. You give me a judgment. The second judgment you are relying on, the Tata Company Limited. Which paragraph? That's page 6, 11, 11. No, page 10. Yes. 36 paragraph at bottom. Slightly beneath that. Yes. If on a reading of a document. Yes. Yes, I got it. Yeah, this judgment. Very old judgment. Yes. That and C. That serial number C of that list of citation. HRA, the compensatory allowance cannot be used as a source of profit. Okay. Who and my lord, I'm relying upon the source of profit. Definitely not. My lord, I'm relying upon direct central which the lordship knows this judgment. Yes. And thereafter R.K. Munshi and Sushil Singh. And to in fact to distinguish with regard to Rafiq machines, the lordship permits me. In fact, I was awaiting the response by in anticipation I prepared a note for that purpose. Distinguishing Rafiq Masik on the ground that it will not be applicable as this is a cooperative bank and has financial repercussions. If a wrongly disbursed amount is not recovered, and that too for a short period, within a short period of time, it was demanded back. In 2010, they were 10 to 12, they were disbursed, and 13, they was the recovery notices were given. So my submission before lordship is serial number A, that where it says that within a short period of time this payment is made, it can be recovered. And the second case is with regard to Chandi Prasad Undian, lordship has their taxpayers' money have stated that. And C have stated, referring to serial number D, have referred to Binapani Patnaik, where the same honorable single judge has held that there is an illegality in disbursement. There's some miscommunication in that context that can be recovered. And I have stated at serial number E that the judgments relied upon by the honorable single judge in Thomas Daniel, Jogeshwar Sahu, and other Rafiq Masik will not be applicable in the case. And the last but not the least, I have given F, Balbir Singh Bandari, flag number 4, where the Honorable Supreme Court has held that recovery is permissible and orders under the so-and-so was granted withdrawn with other subsequent decision. So this is an immediate decision taken subsequently. And as a cooperative bank, your lordship kindly be alert to that fact. Since it's a cooperative bank, its funds are very limited. And in such circumstances, your lordship may kindly reconsider this part. Yes. That's all. Yes. Your writ petition is dismissed. Writ petition was dismissed. Yes, madam. I will dictate the judgment. If I dictate, then it will consume some time. Even for order from day after tomorrow. There is the Oh, we are not to. Yes. Your intervening application is dismissed. Yes. Where is the improved order?
My lord, page, running page 17, my lord.
What's up?
Page 16, running page 17.
Okay.
Where is your application for
I have not, next one.
You are filing an appeal against the order rejecting that application. You are not annexing that application.
I will,
What kind of petition is this?
I will, next one.
2 weeks adjourned. Sure.
Item 15.
So. I am necessary and proper party, lord.
Sir, you show me that how you are a necessary and proper party without looking at it. Court has said you have no locus standi. So we have to find whether the finding of the court is wrong or not. Should go application. Why did? Yes.
Please, lord, footnote.
Just 1 minute. Let me go through.
Malots, item 15, Malots.
Is 15.
15.
15, yes, Malots. We are actually appearing, we are on caveat. We haven't got a copy of the writ appeal, Malots.
You saw the copy right now.
No.
Yeah.
We go north. What is this? If you are, yes, there is a notice.
Let it come then tomorrow.
Malot,
I didn't know that. I thought that. Let it come
Your
tomorrow.
office is not really working so well. Why the office will not intimate you when the filing is there?
The caveat is there. Mirad, I'm sorry, I'll serve the copy right now. Let it come tomorrow.
Malots, I have a problem tomorrow, Malots. Actually, I have to get operated, Malots.
That is why I'm
So,
telling that why are you no, there is already Actually, but they pursued the contempt. A single judge. Is a competent counsel, Mr. Pradhan. Let it come tomorrow because they are pursuing the contempt. That is the problem. Individual order is introduced here. No, I'm sorry, I know. I didn't know that they are in Kerala.
Not this. I'm thinking in a more broader manner. Because another state where once you go and file any petition or appeal or something, that you have to get the caveat cleared first.
Right.
There is a department, they have to present, and then on the back sheet, they have to put an endorsement, either no caveat clause or a caveat clause.
Absolutely.
Unless that endorsement comes, the filing section will not receive the file.
Correct, correct. Well, that is what exactly my
If it is a loss, then you have a knowledge, yes, there has been.
How could it be
This can be affected immediately.
Right.
If after the filing, if something is noted, nobody now watches that particular, what has happened.
Notice it.
So notice, sometimes they do not know the notice is to be given. Can I introduce this system?
That is actually that is the law, Miller. They have to clear the caveat first.
First,
Copy has to be
have the caveat
that is
clear.
also, Miller,
And
our
the
High
moment
Court.
it is cleared, goes
That's right. To the listing. In Supreme Court, that
to
is
the filing, sir. Not listing, to the filing.
to the file.
They will not receive the filing unless there is a
Correct,
caveat
correct.
clearance.
Correct.
Either lost or not lost.
So what happens in High Court, Miller, the other side, he is with the copy
The
here.
president of the bar is not reacting.
No, not reacting, Miller, sir. Look, proposal, your lordship to come up with us, we discuss it is a good proposal, lordship, the welfare of all. Why do
Because that will benefit everybody.
Yes, yes, Lord. We are at the very same time, we can come to know that yes, a caveat has been lost.
On the date of filing, you know that.
So a
there is
caveat has been
already a
lost.
caveat.
That is.
So this McDonald notice has been
Yes,
served. When it is served, where it is, very difficult to
The
recollect.
caveat also the other side cannot know.
No.
Here, most of the time, they
They are not
file it,
sending
send it by registered post. So by the time it reaches, it may take 10-15 days. So the other side may not be aware of it unless it is shown in the
So
cost.
happened sometimes, but the caveat is not at 10:30. The filing is done at 12:30. Now, 9 o'clock it is sent. It will take 1 day or 2 days to receive. But at least once there is a entry in the record that the caveat is filed, even you come at 12, they will say that these are the learned advocate who has lost the caveat. This endorsement comes. So that will help.
Yes, sir. So let it come tomorrow. But my learned friend will be operated on 68, not now. So
No, day after tomorrow.
No, I have your
My
schedule.
friend is
So, no,
my friend is keeping track of me. I'm on it. I'll be
as a
operated
friend,
day
not as
after
a
tomorrow.
opponent.
Velas. I have to put those eye drops and other things, Your Lordship. That is why I have this problem. That's why I'm praying for my lords 2 weeks so that the matter.
No,
Your
but
Lordship.
I filed an IA. I am sort of the private appointed party 4 members 4. Respondent 4. I filed an IA because on the concept. Difficulty, Millard, in one, let me also, since your lordship is hearing. So what is happening, Millard, let me also tell my views to your lordships, Millard. I was also making a submission. Now the single judges, Millard, they are insisting you get a stay or get a contempt. They are evening, Millard, directing for house arrest. Even without a rule, your lordship have stayed 2-3 circles.
Because the contempt application has been dropped because they have already implemented the order.
Intra-court appeal is pending. Your lordship is in session over I did not hear any kind of any in my 30 years of practice house arrest when the writ of appeal is pending. Let me, without issuing even a rule, in a criminal contempt, AG is to be noticed. The clearance under the High Court rule, not contempt rule, the Advocate General sanction is necessary. How can a criminal contempt be initiated against an officer without the sanction of the? Is the rule,
Criminal contempt.
In a criminal contempt, he has to intimate to the Advocate General.
Criminal contempt cannot be issued. If it is a violation of it, then how it comes under the criminal contempt?
That's correct. How?
Order anything.
Certainly, warrant of arrest, NDW.
Where is that order?
Not here, Milord. In many cases, here also, Milord,
Here
the
also,
contempt
bring on.
just implemented.
Bring on.
We told, Milord, we have brought your lordship was pleased to stay, may two such orders at least. I am grateful. But here also, Milord, the same thing. The Honorable Single Judge insisted that we told that the writ of appeal is there, pending before the court, filed in time. Your lordship may grant some reasonable time. He forced the Milord Urban Secretary that you recall your order, reinstate a disqualified person already who has been removed. A person who has been removed from office, it has taken effect since last 1 year and he is not in office. The High Court says that no, you put him in office back.
And
After 9
days, this has happened, my lords.
Municipality was not functioning.
It's not that opportunity was given to the state, my lords, to move the writ appeal.
I am here for last 2 hours. I am waiting.
After 9 dates, my lords, this matter was taken.
When is the tenure was going to expire?
The tenure he has been removed. 1.5 years back.
No, we have been reinstated.
Because I find from the first paragraph of the.
No, that is in 28. That is sorry. 27 August, January, February.
Is it tenure?
5 years. 5 years.
5 years.
5 years.
5 years was going to expire when?
27, I think no. May or June. I think May 27. Next year.
May, yes, but May 27.
But January 1.5 year, Milord, is not in office.
No, I had a different impression that by this time today, a tenure or his tenure might have expired.
No, it is.
No.
This is why I asked, because
But she was out of
remainder
office by
period is
virtue of.
then allowing the remainder period to be enjoyed.
It is Milord there for 6-7 months more. But that is not the question. She was already removed by Section 53 power after grant of due opportunity because of continuous default and
Sir, the copy come tomorrow.
Tomorrow.
The first pattern.
Yes, so great.
Let us see.
So great.
It is a very interesting. First pattern.
Item number 16.
That's 17. My lord friend is also there.
16.
16.
I am the
Item 16.
Appellant may not the petitioner in the writ petition. Challenge the order, annex of 16th page 74 and annex of page 93. The honorable single judge my lord recorded concession where when you have never evidence of concession my lord. That's it, page 74 my lord. Page 74.
No, 74.
That order my lord start from page 80 my lord. Proceed on to take a relevant portion my lord. Page 85 paragraph 7 my lord.
You are challenging an order dated 6/5.
6/5.
6/5 order was modified, and that modified 6/5 order was sought to be modified, but that was rejected on the ground that he has confined his prayer to one person, and now he says I have not confined it. Therefore, the once you have made a submission,
And page 85 of the
page 85, page 85,
paragraph 7
paragraph
and 8 my lord.
7.
Oh, you are not claiming the seniority.
That is there.
That is there.
Honorable single judge my lord. but that I never made such concession, my lord. Then I filed
application.
application, my lord, that
Page
page 89, my lord.
Yes.
Page 89.
In paragraph 4, my lord. Paragraph 4 and 5.
Where is the order rejecting this application?
The next paragraph, annex 18, my lord. Annex 18.
Sure.
Annex last annex, my lord.
Page 99.
Page 99, starts from page 99, my lord.
Rule number proposal, paragraph 6, page 101.
What to do, sir? What the appellate court shall do in this matter?
That concession was recorded wrongly, my lord.
Sir, you have approved the judge who recorded the concession. He says that I have correctly recorded the concession.
Yes.
Now, it's a question of belief and a disbelief. Either the learned judge is to be disbelieved, you are to be believed, or you are to be disbelieved, learned judge has to be believed. So now, what the appellate court will do, you
My
are not present
My right,
when the concession
my
was
right,
made or not made.
my right in paragraph 5 of my application, my lord, I've stated my right, seniority is my right, my lord. Legal right.
Sir, he has not said that you have not claimed, but he says that the time of an argument you have abandoned the.
I have not abandoned. My place is I have not abandoned. Even
Now, whom to be believed, sir? Whether you have abandoned.
ground number A, my lord.
Under the law, one can abandon any of the claim.
Yes.
He can abandon. If he has made 17 claims, he can abandon 1, 2, 4, 5. And for rest, he can pursue.
Yes, ma'am.
So he has proceeded on that basis that you have abandoned one claim.
But that claim, my lord, was wrongly recorded. That is my legal right, my lord. Legal right is what you say in paragraph.
Sir, then order 23, rule 1, I will be just beseeching you to read it. These are your legal right, but you can abandon your legal right.
But I say I have not abandoned, my lord.
Now the question is that how to decide.
Decide. Yeah,
The difficulty is
that I have given, my lord.
proceed.
Yes, my lord.
Please consider if
That
you
you are
proceed that what you say is correct.
Yes, ma'am.
That means we are disbelieving our judicial, I mean the judge, the single judge. I am disbelieving.
Yes.
If we proceed, otherwise then what to do?
That is on the basis of the Supreme Court decision. I have given paragraph.
If the Supreme Court
ground number A, my lord.
yes.
At
Please
page
give us
15.
Supreme Court judgment.
I lost it on page 16 of the appeal memo, my lord. Page 16 of the appeal memo. Ground number 8. Page 16.
1/6.
Of the appeal
Yes.
memo. Second paragraph.
Yes.
Law is well settled, my lord. In case of Union of India versus Monraz Enterprises, 2022, volume 2 SEC, paragraph 14, that concession by counsel contrary to law is not binding on parties. There cannot be an estoppel against law. Further, in Union of India versus Sambit
Sir, there is no difficulty. Here is a case we have claimed two things.
Yes.
One is that you are entitled to a monetary relief, and the second thing is that your seniority should also be taken.
Yes.
There is no law one can abandon or waive his right of seniority.
Well, that is my legal right, my lord.
No, that
Yes,
is what is,
This
again I am saying.
That is covered by the
Sir, these judgments are there which is contrary to law. It says that concession on a particular proposition which is contrary to law
Yes.
cannot be taken as a concession.
This is contrary to law, my lord. This concession.
No,
This is contrary to law.
claiming a seniority is definitely not.
But my lord, your lordship, this honorable court has already settled it, my lord. This honorable court, your lordship, Annex of 7, my lord. And it is already covered, my lord.
Maybe covered.
Covered by
sir.
this.
We are not into this. We are not into this.
Does it come next
No,
week?
no, it's nothing.
No, next week, my lord. Next week, my lord. Next week, I will give
We will be deciding those that way.
No, I will come next week. Next week, I will, because
That's my fault that I express my opinion or my views. That gives a adjournment.
I pray for one. Next week.
So
Next
from
month.
tomorrow, I will just sit idle. I will not express anything. Now it's open to the bar. I will not express anything. I will just keep quiet. After you finish, I will start.
Next Monday, my lord. Next Monday, I will.
No, sir. You are already on a ventilation, sir. Ventilation has to be taken out now. Right time. Please consider this, concession has been recorded by a judge. You have approached the judge that, look, I have never made a concession. Just said, yes, you made a concession and rejected your application. As an appellate bench, what is supposed to be done by us? Question of belief and disbelief. Then we'll have to go by Ramdas Srinivas Nayak judgment of the Supreme. Nobody can contradict the statement made in the judgment by the court, even by filing an affidavit. Then I will go with that.
Next Monday, I will.
No, sir, you know the law. You are veteran in the
No, my lord. I'm guessing. People, so I have given that.
No, you have given a reference. We are relying on that what that judgment really speaks of. Does it really cover this situation? No.
Yes, my lord. In one decision, my lord.
Yes.
All the decisions.
Yes, then the Madraj Enterprises not applicable in this situation. Sumit Kumar Das is not applicable. Uptrod
Mahindra.
not applicable. Mahindra
Yes, my lord.
not applicable.
That is. On that, I will say, well, I will give a say. The Honorable Supreme Court have that.
Yes, also 2019 volume 13 SSC. Just find out.
Yes. I'm giving.
Give it. Thank you.
Paragraph 39 पढ़ेंगे.
Different, not satisfactory in public source. If it is a policy, no. I mean, second two things. See that signal height very simple. Work programs, see multiple things. 30% of the 50% of the only 50% people your the time is about to blood physics. Your government blood physics. Government blood physics and I put blood physics on level here. 71. I'm about 71. About 74. 71. That's 70. I'm about to 70. I put blood physics. So 55 weeks. So we will level, let's see, you want to see 71. Although state June and 3 days will put over the country of various state making.
Thank you. That's the only judgment.
Two more judgment, I'll read two more. Give it. Well, not today, my lord.
Give it.
Tomorrow, my lord.
No, not yet. We have it in just now.
I'll give mark, my lord. Paragraph 14, 15, and 14 to 17. my lord.
Yes.
The fact of the case, my lord, in present case, case was earlier decided by this one, exactly same case. It was covered by earlier decision of the court, my lord. And the Supreme, this one court decided in terms of the Supreme Court decision, my lord. You'll also turn to page 46, annex 7. That same case was decided by this one court, my lord. Same rule, same case, my lord. And this order, my lord, this order of this one court, my lord, it confirmed by the Honorable Supreme Court of India. Counting the training period towards service, also maintained benefits, my lord. No service, my lord. On the basis of the decision of the Supreme Court of India in Puri Sharma's case, my lord. This decision was confirmed by the Honorable Supreme Court in an Annex 8, my lord. And therefore, government has extended the benefit to those petitioners, my lord, who are junior students. In Annex 9, my lord. Annex 9 has turned to the relevant portion at page 53. Government has extended the benefit to others, my lord. Then another batch of cases, my lord, that is Annex 10, page 55. Relying on that judgment is also decided, my lord. And we claim the benefits on the basis of these figures. Therefore, there is a question of not confining to prayer fellow. That is a wrong concession, my record is wrong device. Therefore, I write close from that law, my and two decisions of this on court record.
So, nothing more? Anything more?
In paragraph, the application I submitted, my lord, page 17.
I have already read.
Paragraph 5 of the paragraph 5 of my application, my lord. My right flows from a law, my lord, for seniority, and that has not been decided by, that has not been dealt by the honorable single judge, my lord.
Yes.
Honorable single judge did not deal with that.
Yes.
In the order, this ground has not been dealt with.
Yes. That's all.
On that term, I am citing another judgment, my lord. In paragraph C of my ground, my lord, the honorable single judge was obliged, my lord, to deal with all the grounds, my lord. That is state of
Any judgment on order 23 rule 1? We're talking about order 14 rule 2 principle. What about order 23 rule 1 principle?
on that I will. That's it.
We will also give that principle.
On order 23 rule 1, on 20 order 23, I will address my lord some of this.
Why we have invited you already. You were not ready to honor.
On that I am not clear. Order 23 rule 1, I have not. Not ready.
I will take care of it.
On that I will tomorrow or not. Tomorrow or next Monday, any time.
No.
Only on order 23 I will address.
No. Necessarily, I referred order 23 rule 1. I would have kept one. Why? I do not know. That's my genetic defect.
Good thing, the good thing, Bharat is learning.
What?
Bharat is learning from that.
No.
Wait tomorrow. On order 23 rule 1, I will give the judgment.
No, you need not have to. I know the judgments. I may not rely upon. Let us proceed. I will not rely on order 23 rules. Because that may go against you. But principles I can borrow.
The two decisions were realized that is covered by that judgment that has been taken out of in the order and that has been distinguished and that judgment has been taken out of in the
This is why, according to you, the moment the single bench has distinguished the judgment, division bench is bound to accept that.
No, he said that this is covered by that judgment, he could not produce, now it is a covered case. So that has been taken out of. Thereafter, court has not been convinced. Thereafter, he has considered.
For the disposal.
It's
17.
17.
Related to the other.
no, it's different, my lord. It relates to termination of the law of my lords throughout the state. After the new government came into force, my lord. The
Law officer.
that's why Mr. Kanun was there.
Maybe request maybe taken up some other game.
Termination.
Of law officers, my lord.
How they were appointed?
They were appointed through due procedure under Orissa law officers rules. My lords, 5 names are sent to the district judge. The district judge asks the bar for at least 15-20 names, out of which he selects 5 names. Then in consultation with the collector, they sponsor
What is
these
the
5 names to
duration?
the government.
What is the duration?
Duration is 3 years. 3 years, my lords. 24. They were appointed in 24, so till 27 their appointment stands.
What is the mode of the remuneration or the honorarium?
The honorarium is paid by the government, my lords.
No.
And
What?
More.
It's a lump sum mode or a case basis?
my lord,
basis.
case basis, and they also have a retainership.
Retainership also the case.
Give me the rule. Where is that rule?
71 rules. And this has been dealt with in the Shrilekha Vidyarthi judgment by the Supreme Court, my lord. Similar circumstances, it has been quashed. That was under the UP law officers rules. Rule 6 and 7.
This one now. Yes, I need to- Log. 70.
What is your name? Ashish Vishwa. You have born in the state.
Still survive 71 rules?
Yes.
The present appointment also, the impune appointment is also done under this rule.
This is under the, our appointments were also under the present rules, 71 rules. And my lords, under similar circumstances, if your lordship sees, we have quoted the judgment, the apex court holds that the state cannot act in such an arbitrary manner by a single stroke of pen, eliminate all the law officers in Srilekha Vidyarthi's case, my lords. Similar circumstances, with the change, my lords, in the government, my lords, the law officers were all terminated by a single stroke of pen. We have quoted from the judgment, my lords, and they say the state cannot act in such a manner, and moreover, my lords, a selection process has been adopted for appointment. So that cannot be thwarted with the change in government.
Why the single bench dismiss the?
My lord, he says it's he likens it to a client and a lawyer, my lord's relationship. So if the client wants, he can throw out the lawyer. That is not so. In the case of a PP or APP, my lords, it's not like that, my lords. It's under the rules. There is a selection procedure. Plus,
there's an interesting, because this 71 rules is a very interesting rule.
Yes, my lords. And your lordships may kindly see Srilekha Vidyarthi also, my lords. It lays down this entire point, which I am canvassing.
In my favor, but I will argue. Let it come some other hearing.
2 weeks. 2 weeks.
Why 2 weeks? Let you get ready with your
Tomorrow, okay, my lords.